Welcome. Thanks for making the time. Over the next half hour, we're going to work through Washington's expanded Fair Chance Act. Let me set expectations straight away, because this isn't a background checks course. I'm going to assume you already run background checks. You already know what a consumer report is, and you've already spent a Monday morning inside a vendor portal. What we're covering is the part that actually goes wrong. The report is back. There's something on it. A hiring manager is asking you what happens now, and the candidate is waiting on a start date. That's the question sitting underneath every slide today. The background report has arrived. What may HR lawfully do next? One thing before we start. This is educational information built from the statute, the session law, and published agency guidance. It isn't legal advice, and it can't account for your positions, your exemptions, or the specific record in front of you. Anything fact-specific goes to your employment counsel. All right, let's start with why this landed on your desk now rather than next year. Three things moved at once, and every one of them creates work for HR. The first is timing. Under the expanded rules, the inquiry waits for a conditional offer, not the qualification screen, the conditional offer. The second is reach. This is no longer just a hiring statute. Promotion, discipline, demotion, suspension, and termination decisions involving people already on your payroll are covered as well. The third is money. Penalties went up, and they are calculated per affected person for each violation rather than as one flat number against the company. There's a fourth that gets underestimated, and it's the one that will eat your time: documentation. The law doesn't only tell you what you're allowed to decide, it tells you what you have to consider, what you have to tell the person, how long you have to wait, and what has to be in your written decision. That turns a judgment call into a file. And the dates are phased, which trips people up. We'll get to that in a moment, but hold on to the question on the screen, because everything else today is an answer to some part of it. The report is in. Someone is waiting. What are you actually permitted to do, and what will you be able to show that you did? Before and after, side by side. 6 rows, and I'd work down them slowly. Timing. The 2018 law let you inquire once you had decided the applicant was otherwise qualified. Now, you also need a conditional offer on the table. If your process was built around the qualification screen alone, that's the piece that breaks. Adverse actions. The old law was mostly about the question. It said very little about what you could do with a record once you had it lawfully. The expanded rules go straight at that. Arrest records and juvenile conviction records generally cannot support a tangible adverse employment action at all, and adult conviction records need a legitimate business reason first. Coverage. Applicants used to be the focus. Current employees are squarely in now. Method. There wasn't a prescribed way to assess a record. Now there are 6 factors a covered employer is expected to consider and document. The decision itself. Nothing was prescribed before. Now, if you go ahead, the person receives a written decision with specific documentation of your reasoning and how you assessed each relevant factor. And penalties. With the per-person structure I mentioned, look at what those 6 changes have in common. Almost all of the new work sits after the report arrives, not before it. Dates. These get confused constantly, so let's be exact. EHB 1747 was signed by the governor on April 21, 2025. It became Chapter 71 of the 2025 laws. The session law carries a general effective date of July 27, 2025. That is not when your obligations start. The Act has its own application note, and the note is what governs. It applies to employers with 15 or more employees beginning July 1, 2026. And to employers with fewer than 15 employees beginning January 1, 2027. I'm laboring this because I have seen compliance calendars built on the 2025 date, and I have seen organizations sitting comfortably on the smaller employer date when the larger one applied to them. The effective date of the session law and the phased application dates are 2 separate things. build your calendar on the head count dates. 2 practical notes. Head count decides which date is yours, so if you're anywhere near 15, confirm it rather than assuming. And read the box in the corner. There are statutory exemptions, and we'll come back to them, but they attach to positions, not to companies. Please don't leave today thinking your whole organization sits outside this law because part of what you do is regulated. That reading is how employers get into trouble. This is the compliance sequence. If you photograph one slide today, make it this one. Steps 1 through 3 happen while no criminal history information exists anywhere in your process. You define the job criteria. You assess whether the applicant is otherwise qualified against those criteria. Then, you make an offer of employment conditioned on obtaining the criminal record. Otherwise qualified has a plain meaning in the statute. It means the applicant meets the basic criteria for the position as set out in your advertisement or job description, without considering a criminal record. Read that again tonight with one of your own job descriptions open, because your job description is now doing legal work. Vague criteria make the qualification determination hard to defend. While you are in steps 1 through 3, a covered employer generally may not ask orally, may not ask in writing, may not put the question on the application, may not receive information through a background check, may not conduct its own research, and may not otherwise obtain criminal record information. Every route is closed, not just the box on the form. Step 4 is your disclosure and authorization paperwork. Step 5, after the conditional offer, is the earliest lawful point at which criminal record information may be obtained. Then the real work starts. Classify what you are looking at. Run the individualized assessment. Give notice and a genuine opportunity to respond. Make the decision and document it. Most of the failures I see are not judgment failures. They are sequencing failures. Somebody ran step 5 before step 3. Classification comes first, because the rules genuinely differ by record type. Get this wrong and everything downstream is contaminated. An arrest record means an arrest or a pending charge with no conviction and no other adverse finding. That generally cannot support a tangible adverse employment action. Same for a juvenile conviction record. There is one narrow carve-out, and it gets overread, so listen closely. The arrest record restriction does not apply to an adult arrest where the person is out on bail or released on personal recognizance pending trial. That means the specific Washington bar does not apply to that situation. It does not mean you are now free to act. Federal discrimination law, your consumer reporting obligations, and any local rules still have to be worked through. Honestly, this is the call I would put in front of counsel before doing anything. An adult conviction record is the category where adverse action is possible, only with a legitimate business reason and only after the notice process. Fifth category, and the one people skip past. Information that is inaccurate, incomplete, or simply unclear. Verify before you act. A wrong record is not a business reason. Now the warning across the bottom. Washington defines an adult conviction record broadly. It reaches an acquittal by reason of insanity, a dismissal by reason of incompetency, and a dismissal entered after a period of probation, suspension, or deferral of sentence. It also picks up related material such as citations, arrest records, and probable cause statements tied to that conviction. So do not train your team that a dismissal is automatically arrest only. When you cannot confidently classify something, escalate it. Guessing at this step is expensive. 8 things. Most of these are process defects rather than bad intent, which is exactly why auditing the process matters more than lecturing individuals. Asking too early. A recruiter making small talk. A hiring manager going off script in a panel. A question that quietly survived on an old application form. The prohibition covers oral questions, written questions, background check results, and your own research. Exclusionary advertising. No felons, no criminal background, anything that sends the same message. Old postings and stale job board templates are usually where these are still living. Blanket exclusions. A covered employer may not operate a policy or practice that automatically or categorically screens out people with a record. Automatic system rejection. A vendor label or an applicant tracking system may flag a report for human review. It may not withdraw the offer or permanently disqualify anyone. Picture how this actually happens. The screening system flips a candidate to ineligible overnight and sends the rejection email before anyone has read a word of it. Nobody chose that outcome, and it is still your violation. You cannot hand legal decision-making to a vendor label or an algorithm. Acting on an arrest record. Acting on a juvenile conviction record. Both generally off the table. Skipping the response window. 2 business days at minimum with a real chance to correct or explain. And vague explanations. Failed background check. Not a cultural fit. Safety concern. Company policy. If your written decision could have been drafted before you open the file, it is too vague to defend. Those 8 are the audit list. There is a 9th rule that belongs with them, and it turns up in a different part of the conversation. This is the rule I most often find missing from a recruiter playbook. 2 things are expressly permitted. An employer may accurately tell an applicant that the position is subject to a background check after a conditional offer. And an applicant may voluntarily disclose information about their own criminal record during an interview without being asked. Neither of those is a violation, but both of them trigger an obligation, and the statute says immediately. If either disclosure happens, the employer must inform the applicant in writing of the requirements we have been walking through and must provide the Attorney General's Fair Chance Act guide for employers and job applicants. So decide now who does that and how fast. In most teams, the recruiter is the one in the room and HR is the one who sends the written information. That handoff has to work the same day, not the same week. The script on the left is deliberately short. Thank you for sharing that information. We evaluate your qualifications before considering criminal history information. HR will provide you with written information explaining our process and your rights under Washington law. Then the recruiter stops talking. No follow-up questions for detail, no approving or disapproving reaction, and that includes a sympathetic one. No personal conclusions in the interview notes because those notes are discoverable and they rarely read the way the writer intended. No promises about the outcome, and never tell somebody that a conviction will automatically prevent employment, because it will not. Practice this out loud with your recruiters. A script only works if it has been said before it is needed. The standard, in plain English. Based on what the employer knows at the time it makes the decision, the employer believes in good faith that the nature of the conduct underlying the adult conviction record will either have a negative impact on the person's fitness or ability to perform the position, or will harm or injure people, property, business reputation, or business assets. And the employer has considered the 6 factors and documented that it did. The equation on screen is the whole slide. Underlying conduct. The actual duties of this position. A workplace risk you can name. A documented analysis. Put those together, and you may have a legitimate business reason. Now, the sentence I would put on a wall in every recruiting office. A criminal record is not the business reason. The record is where the analysis starts. It is not where the analysis ends. Here is a test I use, and it has saved me more than once. Take the explanation you have written and imagine dropping a completely different job into it. If the same paragraph works for a warehouse role, a controller role, and a remote support role, then you have not described a reason. You have described a record. The connection has to run from the specific conduct through the specific duties to a specific risk. Theft from an employer connects to a job with payment authority. It connects far less obviously to a job with no financial access at all. That difference is the work. 6 factors. A covered employer is expected to consider them and to document that it did. I would build the questions on the right straight into your assessment form. because a form with the question printed on it gets answered. A blank box does not. Seriousness of the conduct. Ask what actually happened, not what the offense is called. Offense titles vary between jurisdictions, and they mislead in both directions. Number and types of convictions. One isolated matter or a pattern? And are the offenses related to each other or unconnected? Time elapsed since the conviction, excluding periods of incarceration. How long has this person lived and worked without another incident? That exclusion matters because it changes the arithmetic. Verifiable rehabilitation, good conduct, work experience, education and training as provided by the individual. Notice that last phrase. This factor depends on you having asked and on having actually received something, which is why the notice process is not a formality. If you never gave the person the chance, the factor sits empty, and your file shows it. The specific duties and responsibilities of the position. Money, confidential data, vulnerable people, driving, unsupervised access. Be concrete. Job titles hide as much as they reveal. And the place and manner in which the position will be performed. Remote, alone, supervised, on a customer site, inside somebody's home. The same nominal job carries a different risk profile in a supervised office than it does alone in a client's house. Document all 6, not the 2 that support where you landed, all 6, including the ones that cut against you, because those are the ones that show you ran the analysis rather than reverse engineered it. This is what Washington requires before you take an adverse action based on an adult conviction record. You notify the applicant or employee. You identify to them the specific record you are relying on to assess your legitimate business reason. Then you hold the position open for a minimum of 2 business days, giving them a reasonable opportunity to correct or explain the record or to provide information about rehabilitation, good conduct, work experience, education, and training. Then you actually read what comes back. If you go ahead, you provide a written decision with specific documentation of your reasoning and your assessment of each relevant factor. That includes the impact of the conviction on the position or on business operations, and your consideration of the rehabilitation information the person sent you. 2 practical points. For current employees, the statute uses the phrase, hold open the position, which reads naturally for hiring and awkwardly for a discipline decision. Based on the statutory language, the safer approach is this. Do not complete the covered adverse action until the response opportunity has been provided and evaluated. That is a recommended practice rather than a quotation, and it is worth confirming your version of it with counsel. And read the warning carefully. 2 business days is Washington's statutory minimum. It is not a universal waiting period for every law that touches this decision. I will show you why on the next slide. 3 layers, running at the same time. Layer 1 is the Washington Fair Chance Act. It controls when you may ask, which records can support an action, the notice, the response window, and what goes into your written decision. Layer 2 is the federal FCRA, which generally applies when you obtain the report from a third-party consumer reporting agency. Before you obtain the report, a standalone written disclosure, written authorization, and your certification to the reporting company, plus the additional rules if you are dealing with an investigative consumer report. Before adverse action, a pre-adverse action notice, a copy of the report you relied on, the current summary of rights, and a meaningful opportunity to review and respond. After the final decision, the final adverse action notice, the reporting company's name, address, and telephone number, a statement that the reporting company did not make the employment decision, the right to dispute inaccurate or incomplete information, and the right to request another free report within 60 days. Now a correction, because this circulates as though it were settled law. The FCRA does not itself set a universal 5 business day waiting period. What it requires is a meaningful opportunity to respond, judged on the circumstances. Plenty of employers adopt 5 days as an internal standard, which is sensible. Just do not present it as a statutory number, because it is not one. Layer 3 is Washington's own Fair Credit Reporting Act. It may separately require disclosure or authorization before you procure a report, written notice for reports used regarding current employees, restrictions where credit information is involved, the reporting company's details before adverse action, a description of state law rights, a reasonable opportunity to respond to disputed information, and a written adverse action notice afterwards. My recommendation, and this is practice rather than law, build one process that satisfies the strictest applicable requirement. 3 parallel workflows will contradict each other eventually, and it will happen on a Friday. And the 4th box. Washington permits local governments to provide greater protections. Local rules giving lesser protections cannot be enforced where they conflict with state law. Seattle has its own fair chance employment requirements, which we are not going to teach today. Treat the state conditional offer rule as your statewide floor, then check whether a local law adds more on top. This is the part that catches teams out, because the information almost never arrives through a controlled intake. Look down the left. Promotion reviews, periodic or continuous screening, license and credential reviews, driving record monitoring, internal investigations, a manager running a search on their own initiative, a voluntary disclosure from the employee, media coverage, or a call from law enforcement. Very little of that arrives in a tidy queue. The red band is what a manager must not do, and if you push one message out to your supervisor population this quarter, make it this one. No immediate suspension. No quietly removing duties. No denying the promotion, no demotion, no termination, and no interrogating the employee yourself. Then work the ladder. Stop the action. Classify the source and the record, because whether it came from a consumer report changes your obligations. Check whether a licensing, statutory, or contractual screening requirement applies, and whether the position is exempt. Run the 6 factors against this employee's real duties and give proper weight to the fact that they may have done the job well for years. That is evidence, and it bears directly on several of the factors. Then notice and response. Then document the decision and who approved it. One more thing on this slide. Retaliation is expressly covered. An employer may not take a covered adverse action against an employee because that employee, or someone acting on their behalf, makes a good faith report of an actual or suspected violation. To the employer, to the Attorney General, to a labor organization, or to others, or simply because they informed other people what the law requires. So if your HR coordinator flags that an automatic rejection rule looks unlawful, and their next assignment or review suddenly turns, you now have 2 problems instead of 1, and the second one is usually harder to defend than the first. Let us put this into something real. Read the left side with me. An applicant has a conditional offer for a remote customer service position. The report comes back with a 10-year-old drug possession conviction. The job does not involve driving. It does not involve controlled substances. There is no access to company money. The work is performed remotely under regular supervision, and the applicant has 6 years of successful employment doing similar work. Take a moment with the questions on the right before I say anything. So, what record is HR reviewing? An adult conviction record, which means adverse action is possible, but only with a legitimate business reason and only after the notice process. What is the connection to the job? This is where it thins out. Walk the duties. No driving, no controlled substances, no financial access, supervised remote work. If you had to write the sentence linking that conduct to a workplace risk in this role, what would the sentence actually say? What rehabilitation evidence is there? 6 years of successful similar work goes directly to the time-elapsed factor and to the work experience factor. And remember, The individual supplies that information, which means somebody has to have asked for it. Would a blanket rejection hold up? A blanket exclusion is separately prohibited whatever the facts, so that route closes before you even reach the analysis. Here is why I use this scenario. On these facts, the business connection looks comparatively weak. But that is my assessment, not a legal outcome, and it is not permission to shorten the work. Classify the record, run all 6 factors, give notice and the response window. Document what you found. A defensible file looks the same whether the decision goes the applicant's way or not. Different facts, much stronger connection. A conditional offer for an accounts payable position. The report identifies a recent adult conviction involving theft from a former employer. The role includes access to company funds, access to vendor bank information, access to the payment system, and authority to modify payment instructions. Same exercise. Work the questions. What creates the possible legitimate business reason? Here you can actually write the sentence, and notice how different it reads from the last one. The conduct underlying the conviction involved misappropriating an employer's funds. This position carries direct authority over funds and over payment instructions. The risk of harm to business assets is specific, and you can articulate it without straining. What safeguards should you consider? Dual approval on payment changes, segregation of duties, transaction limits, audit review. You are not obliged to redesign the role around the candidate, but a considered judgment is expected, and your written decision should address why available safeguards or supervision were or were not sufficient. A file that never asked the question reads as less considered than one that asked and explained. What must the applicant be allowed to provide? Corrections or an explanation of the record, and information about rehabilitation, good conduct, work experience, education, and training. Why can HR not simply pull the offer? Because the process is not optional. Notice, identification of the specific record, the 2 business day minimum hold, genuine review of what comes back, and the written decision needs the record relied on, the reasoning, the assessment of the relevant factors, the impact of the conduct on this position and on business operations, the rehabilitation information supplied, why safeguards were or were not enough, and who approved the outcome. The lesson. A strong job connection does not remove any part of the process. It just means you are far more likely to survive it. Maximum administrative penalties. $1,500 for a first violation, unless it is waived. $3,000 for a second. $15,000 for each subsequent violation. The Attorney General's Office may waive penalties for a first-time or de minimis violation and provide education and a warning instead. Please do not build a compliance strategy on that. It is discretionary, and the amendments made the progressive approach optional rather than mandatory. Now the structure that actually matters, in the middle of the screen. Penalties are imposed per aggrieved job applicant, employee, or party for each violation, and the penalty accrues for the benefit of and is payable to that person. Where there is no identifiable affected person, the Attorney General retains it. I am deliberately not putting a total on the screen because any number I gave you would be invented. But follow the shape of it. One defective workflow does not produce one violation. A single badly worded question on an application form or one automatic rejection rule produces a repeated per-person exposure across everybody who went through it. That is the risk profile of a process defect, and it is the reason that auditing the process beats auditing any individual decision. On enforcement, the Attorney General may investigate on a complaint or on its own initiative, issue civil demands for documents, written answers, or testimony, pursue administrative sanctions, and file suit for penalties, costs, and fees, including unpaid wages and damages. And the clarification on the right, which is true and very heavily overread. The Fair Chance Act itself does not create a private right of action. That is genuinely useful to know. It also does not remove your exposure under the FCRA, under Title VII, under Washington's credit reporting law, or under a local ordinance. Different statute, different remedy. No 30, 60, 90-day plan. Just a list you can start on Monday. Audit your Washington job advertisements for exclusionary language. Pull criminal history questions off applications. Confirm your sequencing puts the conditional offer before any inquiry, and that the offer is documented rather than assumed. Review your disclosure and authorization forms against current requirements. Turn off automatic rejection in the applicant tracking system. And go and look at how your screening vendor is configured, because a pass, fail, or consider label is not a decision. Then build the decision infrastructure. A record classification process with a route for escalation, a 6-factor assessment form, preliminary and final notice templates, a trigger for handing over the Attorney General's guide, scripts for recruiters and managers, and a named approval authority so your file shows who decided and on what basis. Verify exemptions position by position and write down the statute, regulation, licensing rule, or contract provision you are relying on. Where it is unclear, that is a question for counsel, not an HR judgment call. Coordinate your Washington, federal, and local requirements into one process. And audit how you screen current employees, because that is the newest exposure and the least likely to have a process behind it. 3 things to carry out of here. Delay the inquiry. Evaluate the individual situation. Document the complete decision process. And if nothing else sticks, let it be this. The record is where the analysis starts, not where it ends. Thank you for your time.